Welcome to today's program titled Trade Secrets Audits, Strengthening Your Company's IP Protection. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker. Lauren, you may begin.
Hello, my name is Lauren Leipold. I'm a partner in Seyfarth's Atlanta office. I'm joined by my colleagues Eddie Salcido and James Yu in New York. Next slide, please. So today we want to talk to you about being proactive about identifying and securing your protection of your various IP assets. So we'll start by discussing an overview of the various different types of IP you may want to keep an eye on and determine how those pieces fit into your overall strategic plan. We'll then move into trade secrets specifically, because trade secrets, the focus of today's program, are a species in and of itself and will be require some special treatment. So we'll talk about how to address protection through employment agreements, various policies, internal corporate policies, how to manage computer stored data, which is really key in this context, and then finally auditing your company's existing protection plan to make sure that you have checked all the boxes and done the best you can to mitigate risk in this context. Next slide, please. So let's start by taking a look at identifying and securing IP protection. So what is IP? Why should we care about it? Well, it's a pretty nebulous concept, right? It's intangible by its nature, and so it can feel a bit overwhelming to think about this on the proactive end. It feels a little bit technical. Sometimes it's confusing. What is the difference between a trademark and a patent and a copyright? And how do I figure out how to categorize this stuff? What is important? And frankly, how do I justify, to my business folks, how do I budget to act proactively to protect these things before it's too late? Too often, we will see companies who wait until they decide, well, we want to sell our company, or we want to spin off a piece, or maybe they are sued for infringement. Let me tell you, it is a whole lot more expensive and a whole lot more complicated to deal with it on the back end. So we really want to stress today the importance of protecting those assets on the front end, and then mitigating risk of IP infringement, whether it be infringement risks associated with use of your own corporate IP or third-party IP. Next slide, please. So we could spend an entire CLE on each one of the items on this slide, and that's not the point of today, but I do think it's important, before we dive into trade secrets in earnest, to make sure that we're all on the same page in terms of what are the different types of IP, where do those all fit in, and how do those fit into the larger strategic plan. So starting with trademarks. So trademarks are sort of the most common type of IP you might hear about. It's sort of a common parlance. What it really is a source identifying word, symbol, design, or tagline. So what I mean by that is your brand names, your logos, something that a consumer will see in the marketplace and will latch onto and understand, okay, I know what this product is, where it comes from, and the quality of the product I'm going to get if I purchase it. So the classic example here is going to be your Nike swoosh, right? If someone sees that on the side of a shoe, they're going to understand, this is a Nike shoe and I know what I'm paying for here. There is the term trademark is used for a good, such as a Nike shoe. A service mark is used in connection with the offering of services, like, for example, restaurant services. The important thing to understand here is trademarks and service marks, which are going to be, really primarily important for Consumer-facing brands who are selling consumer goods are also becoming increasingly important to companies who are maybe more in the background in that sense, maybe service providers in the financial sector. We're seeing a lot of phishing schemes and online fraud schemes in which it's really important to pay attention to protecting those trademarks so that your logo cannot be used fraudulently in phishing schemes and the like. Your trademarks are protectable as soon as you use them in commerce, but as I'll talk about in a moment, there are some benefits to registering it federally, although that's not required. Trade dress is a species quite similar to a trademark, but it's a little bit different in that we're talking about the overall look and feel of a product or a package, or even a restaurant. Apple has a trade dress registration on the layout of its store. When you walk into the store, you know it's an Apple store. The classic example here too, in addition to the Apple store, the Coke bottle. When you see that shape, you know exactly what you're getting in that bottle. Again, similar to trademark, you don't need a registration, but it's helpful to have one for various reasons, which we'll talk about in a moment. Copyright, on the other hand, is a category of IP that's relegated to basically the protection of creative works. So your movies, your novels, those sorts of things that you're seeing, the entertainment you're consuming day to day. But more importantly, for today's purposes, this extends to all sorts of items in the business context, such as the content of your website. Copyright is even considered to cover the software coding underlying your website. So that's considered a literary work under the Copyright Act, and there's protections available there. So fairly expansive protection, but again, it's not going to be your commercial symbols in commerce. Unlike a trademark, it's going to be that creative work and the content of that creative work. Unlike for trademarks, you do have to have a copyright registration at the federal level in order to file suit. So that's an important consideration in the copyright context. The next two items on the list, design patent and utility patent, both fall under the Patent Act, but it's important to understand there are two different types of protection with two different lengths of protection. So patents are designed to protect inventions, processes, any sort of product feature that's unique and proprietary to you. And whereas the utility patent is going to be your sort of more traditional patent you think of in the technical sense, the functional features of your product. A design patent is similar to trade dress in that it protects the ornamental aspects of your good. And importantly, for patents, in order to get protection, you've got to disclose everything up front in order to get that registration. So once you disclose that publicly, you do get that exclusive right, but it ends. And so for a design patent, it's 15 years from the time that you obtain the registration. For a utility patent, it's 20 years from the time that you first filed your application for the patent. And so there are various considerations into which inventions you want to make public in this way and get the advantages of the Patent Act in terms of enforcement versus which materials and processes you may want to protect as trade secrets. Publicity rights, I mentioned just so that it's on your radar. This isn't the type of IP that's really traditionally going to be in your corporate IP portfolio, but I'm quite sure you've heard NCAA, NIL deals and the like. And if your company deals with celebrity endorsements, you know about this and you know that these things require a license. It's an intangible right that is protected under state by state law, sort of a patchwork of laws, and there's no registration procedure for these rights, but they are protectable rights. And in order to use them, you have to have a license. You have to have someone sign a release. This includes celebrities and non-celebrities. I've had clients who have innocently taken photos at events and posted on their websites without having the people in the photos sign a release and gotten sued over it. So important to keep on your radar. And then finally, trade secrets, as I mentioned, are sort of a corollary to patents in that they can protect these proprietary processes and inventions and ways of doing things, but is a much more expansive category and can can pertain to customer data, information, and the like, and so needs to be treated in its own separate category. Next slide, please. So briefly, there are three main statutes that you can use to proactively register certain types of IP. The Lanham Act covers trademarks, service marks, and trade dress, as I mentioned. You have to actually be using a mark in commerce. You can file on an intent to use basis, but the trademark office is pretty strict about not letting companies just reserve rights in a mark you like. You have to actually have concrete business plans showing you are about to launch a product in order to get that registration. But when you do have the registration, you're putting people on public notice of your rights. You're getting this legal presumption in court of the validity of your trademark and the fact that you own the trademark and those exclusive rights. And you get the right to use the Circle R. I get a lot of questions about what's the difference between the TM and the Circle R. Well, the TM is used for your common law trademarks, which you claim trademark rights in, but you don't have a registration. You only get to use that Circle R, which consumers recognize when you've got a trademark registration. And finally, for consumer goods companies, whether you are importing goods from outside the US or you have competitors who do, or counterfeiters who do, the trademark registration gives you the right to go to the US Customs and Border Protection, and they will register your mark and seize infringing or counterfeit goods for you to prevent those from getting into the market and diluting the market with those counterfeit goods. So all really important benefits to registration. Of course, you have to continue to use your mark. You have to police your rights and protect against third parties using your mark in the wrong way, or you can dilute or completely lose your trademark rights altogether. The Copyright Act is covering copyrightable matter, and I say that it sounds self-evident, but actually there's a big debate going on right now in courts about what is copyrightable when it comes to AI. And the current rule is that it has to be created by a human, and anything that's generated by AI is not copyright protected. So that's an important consideration, which we will touch on later. But again, it provides you the registration with a public notice of claimed rights, your legal presumption of ownership and validity. You can bring that lawsuit, as I mentioned, and you get the right to statutory damages, which can be pretty significant in the copyright context. And it's essentially strict liability. So really important arrow in your quiver, especially when it comes to website content, which can be difficult to control and police. And finally, the Patent Act, as I mentioned, covers those inventions that meet certain statutory criteria. You have to demonstrate utility, novelty, non-obviousness, and enablement. Just like for copyright, these materials have to be invented by a human. There is a degree of machine involvement that is permissible, but the line is very fuzzy right now, and again, being litigated in courts as we speak. But you do have that exclusive right that really is quite robust and allows you to sue under the Patent Act, get damages and attorney's fees. But you got to make sure you file within 1 year of public use of your invention, and you've got to be aware that once your 20 years is up, your invention goes into the public domain and anyone is free to use it. Next slide. So I just want to quickly note that the registration scheme is super helpful. You should keep it in mind. You should take advantage of it, but it's not the end of the story. First of all, as I mentioned, rights of publicity and trade secrets are not registrable in any sense. And even those rights that are, there are a lot of tricky issues that come up in relation to ownership of those rights that you really need to make sure that you have shored up through contract and employment employee policies, which we'll talk about in a few minutes. For example, in the trademark context, there's a concept called naked licensing, where if you don't properly control the use of your mark, you lose your rights. In copyright, there's a debate over independent contractors and employees and who owns a work, especially when it's a work made for hire, which is a term of art in that context. And then in the patent context, you see arguments over shopyright and whether that creates a license or ownership versus hired to invent. We don't have time to go into detail on any of those matters today, but suffice it to say, you need to make sure that you've got an assignment agreement, assignment provision in your and your employee contracts, which we'll talk about in a minute. And those policies relating to the contracts and just general policies for your employees go to mitigating risk, like we talked about at the beginning. It's really important to think about, making sure that your IP is used properly, and also making sure that others' third-party IP is used properly. So making sure employees know what the policies are, have the proper release forms, and know to go through legal to get clearance if, for example, they have a new brand name or what have you that they want to launch. We've all seen those rogue marketing folks, or at least I have in my day-to-day, who often seek apology after instead of permission beforehand, and it can be a little bit dicey sometimes. Next slide. So I want to take time now to move to trade secrets in particular. As I alluded to before, you've got these pretty concrete, well-established legal schemes that apply to the more, quote unquote, traditional forms of IP. And trade secret is relatively newer and much more nebulous. Here, as the Fifth Circuit said, trade secret is one of the most elusive and difficult concepts in the law to define. Next slide. So we do have a definition from the UTSA. So this is a uniform model law that's adopted in variations across various states, and that gives us an idea: formula, pattern, compilation, program, device, method, technique, or process. And it's got these two key components, right? It has independent value, value that would inure to the benefit of your competitors, and also is subject to efforts that are reasonable under the circumstances, which is wishy-washy language, but reasonable under the circumstances to maintain its secrecy. Next slide. So in 2016, we had some additional clarity from the Defend Trade Secrets Act, which provides us with a federal standard for what a trade secret is. And as you can see, the list is quite large and covers all kinds of different things, which, scientific, technical, engineering, these sorts of things, again, have this interplay with patent law. But again, you have to think about, do I want to keep this secret? Do I want to give this up in 20 years or not? And so there may be some overlap in types of IP, and you have to think about, what do I want to keep secret? Does it fall within these parameters? And there's a lot of arguments that can be made either way, because the definition is relatively malleable in some sense. But again, with the Defend Trade Secrets Act, you still have that reasonable measures to keep the information secret and that independent economic value, which are the two key concepts here that we'll be drilling into today. Next slide. So it's important to identify what it is you are protecting as a trade secret. So as I mentioned, this is a wide-ranging category, right? And you have to articulate that not just after the fact when you're in court and you're trying to defend your rights, but on the front end. As I mentioned from the very beginning of this presentation, you've got to be proactive about this so that you can get your employees on your team to help you protect these secrets. And they can't do that if they don't know what they are. Next slide. So just to underscore again, we're talking about information not known to others. It can't be something that's obvious or something, addresses you've gotten from the phone book. It's got to be really have economic value that you've put some sweat equity into. It's got to be economically valuable in some sense, whether now or in the future. And again, I can't stress enough the reasonable efforts to maintain secrecy. So in contrast to some other forms of IP, we talked about, like, for example, trademarks, you can get that registration, and then maybe you've got some obligations to keep using the mark, to keep maintaining those rights. But with trade secrets, if you're not involved from the front end, you don't have anything protectable to begin with. And so it's really, really important that we focus on what you can be doing day to day to make sure you are taking those reasonable efforts. Next slide. What have courts said might help determine whether something's a trade secret? Here are arguments you can make, because again, the case law differs, but typically courts will look at, the extent that this material is known outside the company, known by employees or others inside the company, what sorts of measures you've taken to protect the value of that that trade secret to you and to your competitors, how much time, effort, and money expended into development? There's sort of that equitable piece. And then, how easy can it be acquired? Like I mentioned, you can't just open up a phone book and take out some addresses, or I suppose these days it would be Googling addresses. It's got to be something that's really quite unique to you and your business. Next slide. So at this point, I want to make sure we have enough time to get into the specifics of what you need to do to be protecting those trade secrets. So I'm going to turn it over to Eddie, who's going to share some information with you on a very important tool in your tool belt, which is employment agreements.
Thank you, Lauren. So as Lauren was just discussing, you've got a suite of rights. You're going to have some registrable rights, as she discussed, with your copyrights and your trademarks and your patents, and then you're going to have the trade secrets. Now, part of the protection is how your employees are going to be bound and how you're going to bind others. So with respect to the registrable marks, as Lauren said, you're going to want to have assignments in place so that your employees know that things that are created or things that they're doing, whether or not they're assigned to the company and belong to the company, and you can register. They can contain sections where the employee has to assist in the filing and such. So you want to make sure that those are in there. But in addition to that, you're also going to have confidentiality agreements, which we're all familiar with, NDAs, and of the like. So you're going to want to identify and define for your employees what groups of information that they're going to be using in their employment or that they're going to be creating that the company considers to be confidential and is going to be protecting, taking those reasonable efforts to protect. Now, when it goes into trade secrets, the most common way to protect those are restrictive covenant agreements. We've all heard of them, and we're familiar with what they are, but they usually break down into restrictions such as non-compete, non-solicitation, potential no hire, and most importantly, non-disclosure. This universe of agreements is been in flux for quite some time, and we're going to discuss in a moment how it continues to be in flux. But it's important to note that these are the tools that you're going to want to have in place, the types of agreements you're going to want to have in place to protect. Now, the non-competition agreements are usually there because an employee is either going to gain knowledge of a procedure or a formula or contacts or customer preferences, and there's a period of time for which that information is going to remain in their head and they're going to know it. So a non-compete pretty much seeks to protect that employee from immediately going to a competitor and employing or using those secrets against the company. Now, those non-competes have come under attack very recently, and and as far as their enforceability, there are factors to keep in mind, but that's the type of thing you're protecting there. Similarly, with non-solicitation, there it's because an employee is going to know where the sweet spots are, what a customer's needs are, what a particular client's needs are, and they may try to use that by just going to that customer and saying, hey, I know what it is you need. So a non-solicit is there to protect against that eventuality. And once again, it's part of that reasonable steps that a company takes to protect itself in order when you're in court to show, hey, these are the types of things that we value and that we've spent a lot of time and money and effort to develop, and it would really hurt if they were used by a competitor. Next slide. So as I said, you've got your non-competition, your non-solicitation of both customers or employees. You also don't want someone leaving and then taking their entire team with them. And these are all going to affect not just what the employee does at the next place, but potentially their next employer. So how you decide to restrict or what you decide to restrict is going to be based on what you're trying to protect. So the restriction can be based on a scope, a particular job title that the individual had, a particular type of product the employee used to work on or was working on developing. In a technical aspect or in a computer company, if they were working on a specific application or if they were working on a specific sector. Even within the broader use of AI, were they working on a specific set of learning? So that scope, what is it that they were doing that you're seeking to keep protection on? It could also be geographical. It could be a particular area of the country or the world that you are working in, that you've been developing in, where the information is the most valuable. So the restriction might be geographic in that respect. And it also could be duration. A lot of trade secrets have a shelf life. Certain information definitely does. So you may not care if it's 2, 3, or 4 years down the road But if in the immediate 6 to 8 months, if you're especially in high tech, that's the area where you're really going to try to focus in on, and that might be what you're trying to defend the most. Now, this can also be used to obviously to protect other assets, like a confidentiality agreement or non-disclosure agreement. Think Coca-Cola, the secret formula. You know, that's something that's kept up under lock and key because of its great value. It's, you know, so you want to make sure that you have agreements in place that are going to protect those, as well as we discussed before, either the goodwill or the customer relationships or the knowledge base you have of a particular customer and the ease of that relationship. Next slide. So when it comes, so you've got your agreements in place, or you're drafting your agreements, your attorney's drafting your agreements. Is it going to be enforceable? Is it going to work? When it comes to trade secrets, a lot of this comes down to state-specific law. There is some uniform law, but most of it comes down to being state-specific. There is state law that restricts the scope. Some states you can't go beyond 1 year. Some states it could be 2 years that you can go into, and anything above that's not going to be enforceable. Certain states restrict what type of employee could be restricted by a non-competition or a non-solicitation. Basically, are they high up enough? Are they involved enough in the development of the trade secret or the procedures or the relationships that a restriction upon that individual is appropriate as far as the state law is concerned or the state's case law is concerned? It could also, because it can be state specific, you might want to consider putting in a choice of law provision, especially if you have employees in multiple states. Certain states, it's going to question whether or not there was adequate consideration for the restriction. In some states, employment alone is enough, continued employment alone is enough. In others, you might have to attach it to an additional remuneration. There might have to be additional benefits or payments or et cetera in order to be able to enter into that type of agreement. And one of the big things to keep in mind is whether you're in a blue pencil state or a red pencil state. And that literally refers to a court's power to reform the restriction. That's a blue pencil state. The court can take a restriction that would otherwise not be enforceable. Let's say it's 3 years and the state only allows 1 year. A blue pencil state is going to allow the judge to be able to knock that down from the unenforceable 3 to an enforceable 1. Similarly, if it's geographic, if the state has a geographic restriction under its state law and you went over that, a blue pencil state, the judge can bring that down and keep it to be enforceable. In a red pencil state, if it's unenforceable, the judge can't make any change to it. The court can't make any change to it. So if you had a 3-year restriction and it's a 1-year state, that's it, it's out. Similarly with geography or with the employee. So it's important to know which state you're operating in, which state the employees are in, and whether you're dealing with a situation where a court will be able to modify the agreement should it be challenged, or whether it's just going to be thrown out. You also have to keep in mind if there's going to be internal conflicts between agreements. You could have a situation where the employment agreement itself is separate and apart, and you can't place certain restrictions, or they're going to be able to move around. More often than not, you might have an employee that's dealing with independent contractors or dealing with vendors and suppliers, and information has to move around that way. Or an employee leaves and tries to solicit a vendor, but you only had an employee non-solicitation or a customer non-solicitation. And finally, if you've got these restrictions in place, another thing to keep in mind is if the business is being sold itself, sometimes the purchaser of the business can place certain restrictions or request that certain restrictions be put in place so that once the business is sold, you can't just restart it back up underneath them, and then what they've bought, basically, they no longer get. Next slide. So, as I mentioned, the ground is shifting with respect to trade secrets. At the beginning of the year, we saw the FTC trying to pass a nationwide ban on non-competes below a certain pay scale and below a certain employee level. Right now, that's still in the courts and it's still being argued. But even without speaking in that broad term with a national restriction, even on state restrictions, there are certain state laws being either enacted or passed or certain case law changing where whether it's a post-termination non-compete agreement, the method of termination, did the employee quit? Was the employee fired? Was it for cause or not for cause? That's starting to affect enforceability. Notice requirements. Are you required to advise the employee before they leave that you're going to be enforcing or not enforcing the restriction? Same thing with the, as we spoke of before, the income threshold. If the employee is making below a certain amount of money, and you have a uniform restriction in place for all of your employees, right now the law is shifting on whether or not employees making below a certain pay grade or having a certain job title, it won't apply to them, although it'll apply to individuals above that threshold. So it's to keep in mind when you're drafting these, whether it's a rollout or not, is it going to be enforceable or what's the current change? So it's important that when you're doing your audit and you're looking through your agreements, especially if it's an older agreement, have any of these changes in the law created a material change to the agreement you already have in place? Traditionally, there have been certain professions where non-competes just don't apply to, the law being one of them. Clients are free to go where they want to go, so it's the concept of either not competing or not soliciting. The types of jobs that are being protected either by law or by case law is expanding. So depending on your type of business, you might want to, once again, look at the agreement you have in place, look at the employees that you have and whether or not they're in one of these areas, which they may not be enforced anymore, or whether you have to make a change to your existing agreement to fall within the changing guideposts of what is and is not enforceable. Next slide. There are certain states where non-competes are outright banned. Right now it's California and Minnesota. Whether the employee signs it or not or rolls it out or not, they're just flat out not enforceable as far as non-competition goes. So if you have employees in those states, or you're a multi-state organization that has employees in those states as well as in other states, and you have a uniform agreement that you use, you want to keep in mind that the non-competition portions of those agreements are not going to be enforceable in those states. Oregon and Washington have recently increased the salary thresholds for those non-competes now. So it's going to be employees at a higher pay scale. So again, to the extent you have existing agreements in place, you might want to look at whether or not it's enforceable, or in certain instances, the business may want to decide whether they want to increase someone's salary by enough to make them fall within, if they are the type of individual that has information that you won't want to be able to keep them restrained, and you're already within, but you're just a couple of $1,000s below. You wouldn't want to fall out of enforceability for that. There are Connecticut, South Dakota, and Montana, as you see there, have some new restrictions. They're adding healthcare and medical professions to the areas that are no longer, that can be restrained on non-competes. Once again, keep that in mind, and especially if you have a national rollout. And there's Missouri also has now presumptions of enforceability as far as whether or not the agreements can be enforced. So you're going to want to check with your local council, and you're really going to want to look at that. And for all of these, it's really when you have agreements and employees in multiple states that you might have something that's enforceable in one area of your business or in one state, but it's not going to be in another. And you're going to want to be able to maximize the agreement, maximize the enforceability based upon that. So you either might want to have state-specific agreements, or you might want to have them drafted in such a way that you can capture those differences. Next slide. So it's going right back to what Lauren said, which is the whole reasonableness. One of the biggest indicia to show a court that you are taking reasonable efforts to protect your rights and to protect your materials is that it's a comprehensive part of your business. It's not just a single agreement that an employee signs on day one. It's not just a single non-disclosure that you roll out with a specific vendor. It's not a standalone thing, but it's something that's woven into your entire business, that you're doing things constantly or have things in place across the board that protect the same type of information. That will go towards that reasonableness and the fact that you are taking efforts. So with respect to employees, you might want to have reference, either to the exact restriction or that there will be a non-compete or non-solicitation or a non-disclosure, confidentiality language in an offer letter, letting them know you're going to be, they're going to be receiving, you're offering them the following positions subject to them entering into the appropriate agreements, and you could list the types of agreements there. Then once the employees do join, you don't just have a non-disclosure, but you have that comprehensive, your non-disclosure, your confidentiality, an agreement or an obligation within the employment agreement to return all corporate materials, post-employment restrictions, as we talked before, either non-solicitations and non-competes, but also ongoing obligation on confidentiality. That's also a post-employment restriction, one that sometimes we forget exists, but it's something that is enforceable. That, you know, even if they're not restricted on competing, an employee can still be restricted on not sharing confidential information. California, for example, you know, you can't have a non-compete, but you can sure enforce a non-disclosure of confidential information. You want your employee policies in your handbooks to also include these concepts of confidentiality and privacy of the company material. Bring your own devices. In the universe of, you know, even partial work from home and hybrid work, people are using their own laptops, their own cell phones. You want to make sure you have policies in place that even with respect to those devices, company materials are being maintained confidential. Non-authorized individuals aren't having access to those. To the extent possible, like with cell phones, you might want to be able to set up a work and personal profile so that information within the device itself can't commute back and forth, gives you an ability to remote delete in that event, and, you know, calls for that. Third parties, as I said before, you're not going to want to just have your confidentiality with your in-house folk, but to the extent you have vendors or contractors that may need access to your confidential information, be it an accountant, be it someone who's coming in to do a software rollout for you, security reviews, wherever you store your information, to the extent you have physical storage or off-site cloud storage, you're going to want those confidentiality agreements in place with those individuals as well, so that once again, in the event that you're in court and that you have to show reasonable efforts, you can show that you've always protected your information and you've protected it across the board. Same thing with security. You want to make sure that your computers are password protected. You want to make sure that you have appropriate software in place to prevent phishing or the leaking of information. Maybe certain types of information only are released to certain individuals within certain groups. Again, it's a matter of being able to show to a court that you've been protecting your information and you've been treating it yourself as a secret and valuable, not just now expecting to roll in and be able to restrict someone else. Next slide. So, as we've been speaking, when you run your audit, keeping all this in mind, you're going to want to look and figure out what is it that we have in place. Do we have non-disclosure agreements in place? Do we have protective covenants in place? Do we have any restrictive covenants in our agreements? Run down what you have and where it is. Maybe you have non-disclosure and non-compete and non-solicitation information in the employee handbook, but it's not in the employee agreements. Or maybe you have one mentioned in the offer letter, but you didn't mention it elsewhere. So you're going to want to go through and figure out what it is that you have in place already, and if the stuff you have in place is kept up with the changing law. Like I said before, some of these states have now increased the threshold on either the employee position or the salary. Have you kept up with that? Have you made those changes? Geographic changes. They've shrunk it. Have you kept up with it? Do you have a social media policy in place? Are you restricting employees from sharing confidential information there? You're going to want to make sure that what you have in place agrees with the other stuff you have in place, that it all protects the same stuff, and that it's all up to date. Next slide. As we said about the employee handbook, to the extent you have one, does it cover both working in the office or working from home? It's relatively new. We've been doing it for a while now, but it's relatively new. Did you change your handbook? Have you revamped it? Do certain restrictions need to be increased, or do certain restrictions in certain areas need to be slightly relaxed? Once again, you want to make sure you're showing the court you're protecting the information that's important to you. If you go into court and you have an agreement that says that every piece of information within the company is a trade secret, you're going to have a harder time convincing the court that you've protected things reasonably, because if you're, as Lauren said, you're protecting Googling addresses or simple names of texts and things like that, that's a court's not going to take that seriously, or not likely to take that seriously, versus if you really only locked down the important information and you relaxed other information. Similarly, if you have an expiration date, so to speak, on certain contact information or certain client information. Put that in there, because then the court can see that you're not just keeping, a contact list from 1953 protected. You're really only protecting the stuff that needs to be protected now, and that you've been diligent and that you're being reasonable in the restrictions that you're asking of your employees and of others. Next slide. Information security policy. This one is one that sometimes gets overlooked because you might have your confidentiality agreements, your non-disclosure agreements. You have your NDAs with vendors, and you think you might be protected, but information, especially in the ultra-connected and cloud age, is complicated, and it has a lot of nooks and crannies. We just mentioned bring your own devices. That would fall under an information security policy when the employees can or can't use their own devices. Maybe there's certain phone calls that they can only take from a secure line. Maybe there's information that they can only download to a secure laptop. They can't download it someplace else. There might be certain encryptions in place where you don't want the encryption key outside of your building or outside of a company computer. That's something that would be in your information security policy, that, lockdown keys can only stay inside. Encryption can only be on a company materials, because once again, you'll have that agreement to return the materials and return that laptop, so you don't have that encryption out in the wild. You don't have that data out in the wild. And having a good ISP in place is something that's going to help you do that. And again, you're going to want to make sure that if you have an existing information security policy, that it has evolved with the changing times and with the changing landscape. If you drafted your information security policy in the mid-2000s, when people weren't working from home and laptops weren't that available, and it was a BlackBerry and it wasn't a smartphone, well, now there's a lot more information and a lot more way to lose your information than before, so you're going to want to make sure that that's updated. Next slide. As we said before, as far as social media goes, you're going to want to make sure that employees aren't exchanging confidential information on social media, aren't exposing social information, aren't talking about something that's up and coming, aren't releasing any information on there. It's not so much restricting an employee from having social media, and indeed there's federal enactment against that, but it's to make sure that the same safeguards you have in place when they're working, they'll have in place with social media, especially if they're accessing social media from a work terminal. You're going to make sure that the ownership of the material is clearly defined, work for hire or not, is it a private social media, and also what types of information they're allowed to discuss on social media. Next slide. We discussed before, bring your own devices. You're going to want to make sure that you're lining all of this stuff up. You're going to want to make sure that it's in place, and you want to make sure that the fact that your employee is bringing their own laptop or their own phone to work isn't going to create a hiccup for you with respect to the rest of your policies. If it's confidential on a work computer, it's got to be confidential on their cell phone and on their tablets. It's just, once again, you want to make sure that you're doing consistently across the board. Next slide. That brings us to AI. This is, of all the areas, this is the one that it's most in flux and is most changing. We know of a bunch of cases that are out there. And with respect to trade secrets, one of the main areas to consider is, to the extent employees are allowed to use AI and these programs, you want to make sure that they're not uploading, or that you're restricting and letting them know that they're not to upload confidential or private company information into one of these public search engines or public, mass media language, so that they're not accidentally releasing something. Because once that goes into that learning model, once that information is uploaded to that machine learning, it's going to be part of it, and someone could extract it after the fact. So you really want to make sure that, one, either you make a policy that employees are not allowed to utilize AI that's not in-house and not internally contained where the information can escape, and if they are allowed to use external, either online, ChatGPT or Copilot or the rest, that you restrict the types of information that they can or can't upload. Lauren?
And I'll just throw in there too, from a copyright perspective, as I mentioned before, These issues are in flux, as Eddie said, constantly evolving, and you have to keep an eye on them. For example, the litigation over what is and isn't copyrightable, what is and isn't protected from a patent perspective. You're going to have to keep that stuff in mind when you're crafting your policies in terms of whether people can use AI, because it will affect whether you can prevent copycats from that collateral that's created down the line. In addition, there's potential liability with for copyright infringement just based on the outputs of those AI tools. But again, in flux. So to Eddie's point, just make sure that you keep an eye on this evolving issue.
Now with that, I will pass it over to James Yu. James, you're muted.
Sorry, I was on mute. Yeah, sorry about that. I'm going to talk a little bit about, some how to manage electronically stored data and prevent this data from, obviously getting disseminated outside the company. So obviously long gone are the days that company data was maintained in a file cabinet under lock and key. And it's important when evaluating how best to protect company data, what the risk factors are in light of the use of evolving technology. It's important to know that the point in time when company data is most often at risk is when an employee who had access to proprietary information leaves the company. And then later on, I'm going to talk about effective offboarding procedures to minimize that risk. But companies should be aware that even if you have an ironclad NDA or a robust non-compete agreement, that's not going to stop a rogue employee from potentially misusing information, which can be taken in a number of ways, some of which I've highlighted on this slide. They could forward data to personal email accounts, although nowadays, a lot of employees have wisened up and, know that their emails are being monitored. So that's less likely to happen, but it's still something to be aware of. Use of flash drives, uploading data to personal cloud accounts, using Dropbox, using cell phone cameras to record, internal meetings. I've seen that happen in one of my cases. So, you obviously want to have robust policies in place that you can enforce should you have to litigate against any of these rogue employees. And remember, when we talked about the definition of a trade secret, courts look to what reasonable measures the company has taken to maintain the secrecy of such information, and the lack of protective measures may be construed against the company. And while you don't need to have like an exhaustive security system in place where everything is accounted for, it's important to know that, where these risk factors are so that you can minimize your risk. Next slide, please. Another risk factor to be aware of is if data is stored or managed by a third-party vendor, which is a typical case in a lot of days where data is not necessarily stored in-house. And in such situations, you want to make sure that you lay out clear definitions about who owns the data. These lines can be particularly blurred when companies use a third-party administrator to promote data onto a database or potentially develop a database to manage the company's, sales data, for example. And that data, while the data might clearly belong to you, the database itself might not, or the underlying software code to the database may not necessarily belong to you. So you want to make sure you outline clear definitions in your agreements with third-party vendors who manage your data, who belongs to what. And you also want to make sure that you have unfettered continued access to your data, so that it doesn't get withheld for any reason should you need it to have it, or that's not going to be compromised in any way. Next slide, please. So in this slide, I simply lay out a few security features that companies should be thinking about when assessing a protection plan. It should obviously now be standard across companies that, to the extent possible, to employ two-factor authentication for all devices. A lot of businesses are now being conducted over smartphones. And as Eddie mentioned, it's critical to have a robust mobile device policy in place. One thing I want to highlight in this regard is that you want to make sure employees don't use any unapproved apps on their mobile phones. This should be easier to enforce if you have company issued devices, but it's obviously more difficult if employees are using their own phones to conduct company business. The unapproved apps can raise a host of issues. Some apps may be vulnerable to security leaks or leaking personally identifiable information, which you don't want to happen if an employee is using a personal phone or one of these phones for business purposes. A lot of employees may also be using different messaging apps to engage in business communications, such as WhatsApp or Signal. These are particularly problematic because the messages may be inaccessible to the company when necessary, whether for litigation hold purposes, discovery purposes, or when just trying to assess whether the data has been leaked or compromised in any way. And we also just talked about offsite retention and management of data, and it's important to ensure that data is always encrypted, whether at rest or in transit, to further safeguard such information. Next slide. I know we're a little short on time, so I'm just going to kind of summarize this quickly, but here I've listed a few other recommendations to guard against cybersecurity threats, external threats. And one thing to keep in mind here is that there will always be an increased risk that data will be compromised when employees are accessing company network in public spaces or non-secure Wi-Fi. And remote access through a VPN with strong end-to-end encryption generally ensures stronger security in such scenarios. But one thing I want to highlight is that it's particularly critical when employees travel to foreign countries where there may be an increased risk of corporate espionage or cybersecurity threats. You want to make sure that employees engaging in such travel are trained on appropriate protective measures. Next slide. So now that we're aware of all these risk factors, what should a company be doing specifically, when auditing its own protection plan? So the first thing is you want to identify and assess your risk exposure. Step number one, obviously is you want to evaluate what policies and procedures you already have in place. And Eddie spoke to this quite a bit. Do you have a confidentiality policy, social media policy, and do you provide training on these policies? So, you want to look at, has the company recently updated its employment agreements? I don't want to rehash anything that Eddie has said in this regard, but the short end of it is that, given the constant changes in the law, your non-competes, non-solicitation agreements that were signed even just 2 or 3 years ago may no longer be enforceable in certain states. It's important to know where all your employees are located. What states are they in? Do they work from home? A lot of times I work with clients who don't have ready answers to these questions, because especially for nationwide companies where you have employees just located all over the place, some working hybrid, some going to the office, some not. And this is particularly critical when analyzing what state laws might apply with respect to your employment agreements. And particularly since the pandemic, we've obviously seen a dramatic shift of employees now working in remote or hybrid environments, which has made this issue thornier. You can have a uniform choice of law, which might help. But again, certain states such as California, Colorado, Minnesota won't even recognize out-of-state choice of law provisions. So you want to keep these pitfalls in mind. Again, you should, take an inventory. Are employees using firm-approved work devices? Having company-issued devices obviously helps in this regard. But understandably, a lot of companies still have a BYOD policy, and you just want to make sure it's a uniform policy across the board. And if they're working remotely, again, you want to make sure they have two-factor authorization and are using VPN access. And then, of course, you want to have procedures in place to make sure for when leavers return, that leavers return company property and company devices. And I'll talk more about that later in terms of exiting employees. So all of these data points that will help the company prepare a robust protection plan that addresses all these risk factors. The next slide, please. Okay, so this seems obvious, but it's important to limit access to confidential information to those on a need-to-know basis. And there are a number of resources that can be used to achieve this. The reason why I brought this slide up, and while it may be obvious, is because Eddie and I actually litigate a case where lots of times information may be shared on a confidential basis, but suddenly the same exact information is used as a data point on a slide in a firm-wide presentation, and the data is no longer confidential. And we were able to successfully argue that, in terms of an opposing counsel saying, well, all this stuff was confidential. It says, privileged and confidential on it. And then next thing you know, we were able to point to a PowerPoint presentation that the company CEO gave at a firm-wide meeting in front of 500 people, included clients and other people and third parties. And suddenly, hey, that same data was on that slide. So you want to make sure, not only that information is appropriately marked confidential and that it's only shared on a need-to-know basis, but, obviously, if you're going to draw any data from that slide onto any publicly available information, that needs to be known so that you don't look silly in front of a court when you're trying to make arguments that this stuff is trade secret confidential. Next slide. So you already have a confidentiality policy in place. And your employees already signed NDAs. What's next? So here again, I'll just kind of quickly go through this because we're short on time, but I've highlighted some key factors of an effective protection plan, some of which we already discussed. But the one takeaway here I think I want to stress is that it's important to hold regular training sessions and meetings to address confidentiality obligations. during these meetings, the company can highlight what types of information is particularly critical and confidential. Just having a policy in place is not enough if the employees aren't aware of their policies. Employees, a lot of times they sign agreements when they started, and then years later they forget what they signed. So it's important to keep them reminded of what their obligations are by regularly communicating with them. Next slide, please. And so ultimately here, you want to make sure that you create a culture of confidentiality so that everyone, employees and employers alike, all become stakeholders and value the confidential information that's being protected. Again, this is beneficial not just to the company, but to current employees, so that, especially employees who are involved in a sales role or who are involved in R&D, whose livelihood depend upon, the secrecy of the information or dependent upon customer relationships, will appreciate that the efforts that the company goes to safeguard such information from competitive misuse. We talked about training, we talked about marking documents confidential, and it's important, of course, that all security protocols are easy to understand, familiar, and uniform. And it's easy for employers to just acknowledge, at the start of their employment, that this is all, that they understand their confidentiality obligations, but active training sessions and modules will help make, these obligations easier to understand. Next slide, please. Okay, so finally, once you have your protection plan in place, you want to make sure you stay ahead of the curve and be proactive about staying on top of updating your policies so that they're not, they don't expire in any way, or they don't become, sort of a dinosaur in some regards. And this is particularly critical in situations where companies grow rapidly by acquiring other businesses, which may not have as robust of a security system in place. And oftentimes, a lot of litigation that I'm involved in happens when a company acquires another business, and the target business may have a different practice, culture, or procedures and agreements in place, and they're not updated after the target company gets acquired. And a lot of litigation arises because employees of the target company haven't been updated or trained about what's confidential and what's not confidential. They may have different agreements in place, so you want to make sure that you have uniform agreements in place, particularly after a new business has been acquired. Next slide, please. So this slide illustrates that the most effective protection plan just involves a synergistic relationship between the three pillars that Lauren, Eddie, and I have been talking about today. First, you need an effective management system of trained, committed people routinely following these procedures. It's helpful to obviously to have a sophisticated IT capable of providing the physical security, whether it be cyber threats, or that they implement triggers so that the company becomes aware if data has been exfiltrated. In one case I worked on recently, alarm bells literally started whistling when one of its software engineers downloaded the source code of the company's database to a server up to a personal cloud storage account. And based on this, the company was able to react to it immediately without having to get involved in litigation to try to get that data back. And of course, you need to have legal in place to ensure appropriate registrations, agreements, and enforcement mechanisms are in place. So it's important, obviously, that legal also stay on top if litigation is necessary. Failure to enforce its rights right away could end up having competitive information in the public domain, and you lose ability to enforce your trade secret rights should that happen. Next slide, please. So, I finally want to address effective onboarding and offboarding procedures. And a lot of this should be obvious, but it's important to make sure that employees execute their agreements, handbooks, policy acknowledgements upon commencement of employment. It's also important that agreements be countersigned. A lot of times I see situations where the employee signed the agreement, but it hasn't been countersigned by the employer, and this could raise enforceability issues in certain states. Eddie mentioned this, but you also want to make sure that you comply with mandatory notice provisions for employment agreements that contain restrictive covenants that some states may have. Those can be waived by the employee, but in certain states you have to allow up to 14 days for an employee to review and sign an agreement that has a non-compete or non-solicitation in it. And then one thing I don't think we really talked about, but you want to make sure an employee understands not to bring any confidential information of their prior employer with them to the new company. Not only does this present a risk of exposure to litigation, but it could entitle the prior employer to invasive discovery through your company's network to see if any confidential information has infected your servers. And next thing you know, you have a competitor rifling through your data to make sure that their information hasn't been taken, but then your information ends up becoming compromised. Next slide. So we already talked about the importance of training. I'll just skip this one. Next slide. Finally, you know, I want to talk about the offboarding process. So we talked about, you know, how it's important for property to be returned, but the exit interview is an important checklist that's critical here. Even if the employee refuses to answer, it's probably important to ask, you know, why the employee is leaving, where the employer is going, particularly if the employee is subject to post-employment restrictions. And, you know, if they are going to a competitor, even if they're not, it's important to remind them of any post-employment restrictive covenants and to provide them a copy of their employment agreement on their exit interview. And then you want to make sure that the employee returns all company property. And I can't stress this enough. A lot of times this doesn't happen as expeditiously as it should. I would oftentimes recommend to clients that they should consider having somebody go out to the employee's home to retrieve the devices if they work from home, rather than, you know, relying on them to return in the company, because then you're chasing after them after they've already left. And sometimes even just sending a box to have them ship it back, that could take a lot of days, which is critical time if they've gone to a competitor, and it risks data spoliation or misuse. Next slide. So finally, here are some other considerations, you know, you should consider. Again, I'm out of time, but you know, it is important, I think, to stress here that if they are using their own personal devices, if they have any company data on their personal devices, you want to make sure you make arrangements to have them returned. Your IT policy should prohibit any wiping of devices or removal of data of any kind from any of company issued devices. A lot of times, if employee uses a company issued device for mixed use purposes, they may end up wiping that device. So you want to make sure that doesn't happen. You want to make sure that any text messages on a company issued device that they use for work purposes are all preserved. So this should all be spelled out in your employment policy. With that, I'm just going to skip to the next slide. Developing a comprehensive protection plan. I know we're out of time, but I think Lauren just wanted to touch on, you know, some protection plans from a IP perspective.
Yeah, I'll just leave you all with this. Think outside the box here, right? You know, it's easy to know, you know, you're familiar with these sort of traditional copyright trademark concepts, but you may not have thought about your employees' data on their cell phone as being a protectable asset. It is, and you need to take those measures now and be proactive about it. So be creative in the ways that you implement your federal registration schemes, but also, you know, consider strategically overall in terms of your portfolio, does this make sense to protect as a trade secret, a patent, et cetera? And then take those measures and steps that we've discussed regarding employment agreements, internal policies, data security measures, and fostering a good corporate culture to really underscore those points. I see we have some questions in the chat, but I know we're out of time. So we will follow up with you all. And we have a CLE code for you to scan to get credit for today's presentation.
And if you are on audio only, the code is SS8749. SS8749.